There's been a lot of legal threats going around lately against me, against Dr. K when he was playing his piano in public. Other people were caught in it when it was being filmed and they asked for it to be deleted, and now apparently are making legal threats against him. So this now overlaps with this channel, my money channel here, where I help you to build wealth, because one thing I often see as a lawyer is people losing huge chunks of wealth on legal fees when they really don't need to. So there's an overlap between all of these issues here. Now, when someone receives a threat of legal action, whether that be online, be it in a letter, a cease and desist letter, or a full-blown letter of claim which has a valid basis of claim underneath it, many people will run to a lawyer. And before you blink, the lawyers, I mean, this sounds funny coming from a lawyer. I'm a lawyer. For those of you that don't know, I run the Black Belt Barrister channel. This will sound funny coming from a lawyer, but when you go to a lawyer, the lawyer immediately is usually going to ask you for a couple of £1,000s or dollars on account. Barristers don't hold money on account. That's different. I'll come back to that in a minute. But lawyers are going to ask you for thousands of pounds on account just to sit down and talk with you, go through the issues, read the correspondence. And a lot of this is a complete waste of money, for the reasons that I'll explain. Now, there are situations when you absolutely should go and seek formal legal advice, and I do say when you get a full letter of claim and there's quite probably a real basis for the claim underneath it, then of course you might need to seek formal advice. But so many situations, people are bullied into submission and bullied into spending money on lawyers that they really ought not to be spending, which is a huge waste of money. We've known clients before they came to us as barristers spend £40,000 on legal fees to get to a certain point where they're not even at court yet. They've been back and forth in correspondence, they've had advice and all sorts of stuff. But it turns out when they had expert advice from one of our then Queen's Counsel, now King's Counsel, of course, the Queen's Counsel, then Queen's Counsel, actually said, I can't even charge for this time because it's so clear cut that there is no claim against this person. I don't feel right charging for the services, and put one letter in and killed the whole thing off there and then. That was after a reminder. That was after spending £40,000 in legal fees in the correspondence back and forth because of threats, legal threats. So this video is not to scare anybody, certainly not to scare Dr. K, and it's not to be taken as legal advice or financial advice or anything else, but it's real situations. This is what really happens sometimes. People are scared into spending thousands, tens of thousands of pounds when they really don't need to, because there's no underlying basis of a claim. That's one reason I do these videos over on Black Belt Barrister, to help people understand law, not as a replacement for legal advice, but just to give you a better understanding of where you might be before running off and spending money with a lawyer. And case in point, there are other situations that don't need lawyers involved either. And it's usually because if I explain this in a sense that the court is there to resolve disputes and make decisions where other people can't make decisions for themselves. So parties have a disagreement. They can't then agree on a resolution, and so the court provides a resolution by deciding who's right and who's wrong. And that costs money. And very often it's a very straightforward situation. So for example, one example, now this can't be taken as blanket advice for everybody, but it's certainly advice on how to not completely blow your inheritance before you've received it by arguing over it. But where you are two or three or four parties that are going to receive an inheritance and it's supposed to be shared, and one person is designated executor, or everyone's designated as executors, and obviously everyone is beneficiaries, and ultimately an argument ensues as to what to do with it. Now, very often the argument is over a property, and one party says, well, now is a rubbish time to sell. Let's rent it out and make some money. And the other parties say, no, we don't want to rent it out. We just want to sell it. We don't want to become landlords. We want to sell it. There's the disagreement. But those situations are more often than not absolutely crystal clear. If the specification in the will is this property is to be sold and distributed equally among 3 beneficiaries, that is what's going to happen. Bar some very unique circumstances that would mean that doesn't happen, which are very few and far between, they are usually very straightforward. Now, obviously, going against what I'm saying here, you would obviously need formal advice if you really firmly believe that you fit in with one of these different situations. But generally, most people will spend thousands of pounds arguing over a point that has no basis at all. So one way I can help you to save money in this regard is by going straight to an expert for advice on your situation. It might sound more expensive up front because it will be a larger chunk than, say, 1 or 2 hours up front, but you will get the advice right at the beginning, and then you will know exactly where you stand. And if the advice is you've got no chance of fighting this, just agree, because if it goes to court, it will take thousands, tens of thousands of pounds, and you will lose. So don't do it. That's the advice that you will get if you go to an expert for that advice. Now, if you go to a lawyer and say, please write to them and challenge it, then the lawyer will probably challenge it for you. It's got to be properly arguable, and it can't just be a whim, in which case I would be complaining to the lawyer, because if they're running a really bad argument that has no merit in law or fact whatsoever, then you've possibly got a claim against the lawyer. But if you go straight for the very specific advice, and the advice says you've got no chance, don't even try, don't spend money on this because you'll get nowhere, then you've got your advice. Now, then you should agree, and you've saved yourself tens of thousands of pounds. So in this situation that we've got with the threat against me, which I'm using to help people understand these things, and the threats that have been made online, sort of in the third person against Dr. K for all this privacy and whatnot, it's really important that people, if they do spend any money on advice, that they go straight for expert advice right at the outset and not get into this back and forth ping pong match of expensive letters between lawyers where nobody wins but the lawyers. Because there's only 2 things that matter. Is there a claim at all? And is there any defense? And if there's no claim, there's no point having this ping pong back and forth. So if you end up in any situation like that, my firm guidance to you is to go straight for expert advice right at the outset, but only if there's a genuine letter of claim coming to you and it sets out a proper basis of a claim, and a reasonable person would infer that this really does look like there's a claim there. I hope that's helpful. Please do subscribe here. This is my 3rd channel that I run, helping you to build wealth. And this is one way not to lose that wealth before you've even started building it. I hope you found it useful. Please do subscribe, and I'll see you next time.